let's talk a little bit about what's before the legislature right now. They're virtually identical. There's a little bit of difference, but on the main substantive points, they don't differ at all. They all acknowledge that the purpose of this legislation is to authorize a disease control program that will combat the spread of infectious diseases like HIV and hepatitis, both hepatitis B and hepatitis C. And so that's the overarching purpose, and everything in the legislation will be interpreted in light of that purpose. The bills that are before the legislature authorize health authorities or organizations that contract with them to establish a program, and they have several things that they require of the program. And there are three things, but primarily they provide for the anonymous exchange of used hypodermic needles and syringes for used ones, and that's the essence of a needle exchange program. And they've got some other aspects. For instance, they require the program to offer education on prevention, which is something that the volunteers were already providing, and also to assist program participants in obtaining help. One of the things that we do know is that a lot of these folks who come to the people who are providing needle exchange programs, they may have no other access to public health officials. They live in such a marginal state that they may not have very much contact at all with people who can actually provide them the services and the programs that might get them out of the life that they're living. So that's another aspect of the bill. When you look at the bill as a whole, it's clear that it's motivated to alleviate the suffering of these folks. And this is actually a heroic act on the part of these legislators to do this, but they're sticking their neck out somewhat. And it's clear that the purpose is to provide the life-saving services that the needle exchange provide. One of the interesting aspects of the needle exchange bills, all of them, are that they actually provide that volunteers and employees who are engaged in the activities of the program will not be prosecuted for violation of the paraphernalia laws under certain circumstances. Specifically, it's an exception to those laws if the hypodermic needles and syringes are being delivered through the program, so they're part of the program, and if they can present evidence showing that they're an employee, volunteer, or participant of the program. And clearly the intent is, what they don't want to do is immunize people who are, for instance, trafficking in drugs from prosecution for paraphernalia laws. They only want to immunize the people who are actually working pursuant to these programs that the legislature enacts. And you know, as we all know, I mean, it goes without saying, the people who are working in these programs, these harm reduction programs, they're working for the benefit of these people who are suffering and may suffer infectious diseases. Whereas, obviously, the drug dealers and the pushers and so forth, no one wants to shield their activities. They're the ones who are enslaving these people. So what makes this bill, you know, when you view it in light of what occurred with the three volunteers who were cited a year ago almost, had this been in place, those volunteers would have been shielded from liability because they would have shown, assuming that the program had been established and that they had some connection with the program, that participation in that connection would shield them from liability. That's obviously to prevent a chilling effect on the services from the fear of prosecution for violation of the paraphernalia laws. The actual pilot program didn't have this sort of detail in it, and so that created some area for dispute. It was a contentious issue. The legislature had funded a pilot program for needle exchange, yet had not actually included in that bill an exception from liability, and so there was a dispute that was brought up before the Attorney General. Is there an exception to the paraphernalia law for prosecution? Where does it apply, and so forth? This will eliminate that. There will be no further dispute as to the application of the criminal laws. A couple of issues that I think we're going to hear discussed And let me just say, on the whole, this legislation is a huge leap forward from where we were before. I mean, it actually establishes a program and it establishes an opportunity for volunteers and employees to pursue the program without fear of prosecution. There are some elements, and I think that Bill Martin is going to address those, that may raise questions that are worthy of discussion, and that is the one-to-one requirement. There's a one-to-one requirement. That is, it says the program is to be designed to bring in an equal number of needles to the number of needles that are distributed. How is that to be implemented? It doesn't exactly say. Obviously, the healthcare professionals have to design the program, and it will be designed in a way that will satisfy that principle in light of its purpose of preventing transmission of these infectious diseases. But that's an interesting issue that will require some interpretation and some thought and planning on the part of healthcare professionals. The other thing I would like to see in this would be broader protection, not just for distribution of needles and syringes, but for associated paraphernalia. As many of you know, in needle exchange programs throughout the country, the addicts will also be given a little cooker and a filter. And why is that? Because if they have a perfectly clean needle or a perfectly clean syringe and they use a dirty cooker that's infected, they will transmit the diseases. I would hope that the statute would be construed consistently with the purpose of the statute. Having said that, that is one area that I'm worried about. Another thing, in some programs, they distribute bleach to users to bleach their needles where they may not be distributing needles. Is that paraphernalia? Would that be shielded by this particular language? That's an open question. I would hope it would be. I would argue, as you might imagine, that it would be. But it's an area, hopefully, that would not create some dispute or some contention or potential liability. Finally, it's interesting that, and this is not uncommon, but all the legislation is very clear that prior offenses that this does not retroactively apply to decriminalize prior offenses. And I'm sorry for the 3 people who got their tickets a year ago. It doesn't. It's clear that it will not wipe away that offense, but given that the district attorney's office has not pursued those charges, and what I think is a great exercise of judgment on this point, and is letting the legislative process work, I don't think that will be of consequence. But the legislation is very clear. It's not going to immunize retroactively people who were involved in needle exchange programs from prosecution. Going forward, it's going to be a great shield from liability, and therefore a protection, and it'll encourage such programs.